Does that mean it's showtime? I got 10:29, but never being stickler for timing. I'm going to go ahead and get started because I got 45 minutes, and it's up to you guys to tell me when the 45 minutes are up, because I will just keep going. I will also give my usual disclaimer that I have a plan. I hate plans, but I'm happy to treat this like an appellate argument. So I will start, and you just jump in with questions. And if you want to hijack the whole presentation, that's fine, because there's lots of great stuff to talk about. But I'm going to start by wishing you happy opening day. For those of us who are Supreme Court geeks, this is it. This is opening day. The court this morning was hearing their first two cases. They have a mascot this year. Their very first case is dealing with this really cute little critter. That's a dusky gopher frog. And we'll talk about the dusky gopher frog in a little more detail in just a minute. I was going to start off with the dusky gopher frog, but my justices are hanging on perilously by a thread. They keep falling down on the job. That is no political comment about the Supreme Court. But I did want to say there is one major change this year, and that is the seating assignment. So when the term ended back in June, this is their seating assignment. As you know, the chief always sits in the middle, and then based on their seniority on the court, other than the chief, they align themselves. So Justice Kennedy was number 2, and then Justice Thomas was 3, and then Breyer is 4. No, wait a minute. Got these guys mixed up. They fell off, and I tried to put them back up. So it was Kennedy was 1, Thomas was 2, Ginsburg 3, Breyer 4, Sotomayor 5. That's not right either. See, they all fall down, but it's all going to change, right? Because, all right, if you were here in June or somewhere else in June, I did a presentation at the best practices thing, and I did some 10 takeaways, and one of the takeaways was how Kennedy was still the decider, and it was all plot for him to kind of set up this term as being the great Kennedy swan song. And then like a week later, he announced his retirement. So that was wrong. So the big change, of course, is Kennedy is no longer, so it doesn't matter if he falls now. But what it also means is that everyone now has to switch their seats. And so it makes it really easy, since Kennedy was the most senior, that you now just kind of switch. So Thomas is here, and Ginsburg is here, and Breyer is here, and like that, like that, like that. Gorsuch is really glad that very soon he will no longer be the youngest judge, because he's the one responsible for opening and closing the door, getting coffee, running errands, all of that other stuff. So he only had to do that for 1 year, so he's a happy camper. And then, I was doing this on Friday while I was kind of distracted. It's okay. And so I was going to paste this guy's face up here, because that's what it looked like. So I had to go in this morning and put that one up instead. And now they can just go ahead and fall, because they were sitting this morning, they're still sitting this morning considering cases. And we're not really sure what's going to happen with the Kavanaugh nomination. I can tell you what my gut instinct is, and that is that the the limited FBI investigation will come back in a week and not have decided anything at all, which gives cover to people like Jeff Flake and Lisa Murkowski and Susan Collins and Joe Manchin and Heidi Heitkamp to go ahead and vote for his confirmation. So unless something goes on in the next week, and I know Michael Avenatti is working on it, that there may be, we're probably in, this was the cover that they needed to get the more comfortable margin. Again, before I get to my friend, the dusty gopher frog, I was scrolling through my social media. I'm not very social media literate, but there are a couple of people that I want to point out to you on Twitter. If you're in Twitter, they probably also have Instagram and everything else. And one is a reporter with the Bloomberg News. She's a legal reporter. Her name is Kimberly Robinson. And she posted this morning a couple things that actually shows that failed nominations to the Supreme Court are not that rare, or not as rare as you would think. She has 118 that were confirmed and served, 12 who were rejected outright, 12 who were withdrawn, 10 upon whom no action was taken, including our friend Merrick Garland. 7 declined the nomination, and 3 were postponed. And I think they're still postponed, so they're postponed indefinitely. So 118 successes, and by my quick math, like 44 that didn't get in. So it's not a slam dunk. President nominates you, you're in. Her next one, though, was also really informative. She lists the closest successful Supreme Court confirmations, because there is some thought that Kavanaugh's nomination, we only got 2 more to go, Kavanaugh's nomination will be 50-50, in which case Mike Pence, Vice President Pence, will have to come in and break the vote. That's never happened before. The closest vote was nominated by nominated by President James Garfield. Justice Stanley Matthews won 24-23. Clarence Thomas is the second by percentage, 52-48. Nathan Clifford, also nominated by James Buchanan. I think there was something going on in the country around then. It was 26-23. Lucius Lamar, nominated by Grover Cleveland, 32-28. And then Justice Gorsuch, the most recent, was 54-45. So what that tells you is that usually nominations are not that roughly contentious. So I would say definitely put Kimberly Robinson on your follow list. There's one other one that I wanted to draw your attention to, especially if you're going to plan on using cases or the court procedures with your kids, and that is there is someone out there with the moniker High School SCOTUS, and it's actually just designed by a high school student, and now she's kind of roped in some of her friends. And they post analysis of arguments and cases coming before the courts and thoughts and observations from a teenage perspective. So it's not just, old guys kind of talking down to students, but it is students talking about the importance of certain cases to other students. So search for High School SCOTUS and definitely follow her. She's been on the news a lot lately because it's an oddity that you have a teenager who is that fixated on the Supreme Court. I know I was back when I was her. Well, now, because unless she's like 17 or 18, no, I still was not fixated. My fixation began my senior year in high school and then has continued ever since. So let me go back to our friend, the dusky frog. Dusky gopher frog. The dusky gopher frog is the first case considered by the court this year. In fact, they probably just finished that argument. It was scheduled for 10 a.m. Eastern. Yep, 10 to 11. The dusky gopher frog is a cute little bugger if you like frogs. The dusky gopher frog is also an endangered species. The dusky gopher frog, I'm going to just call him the frog after this. The frog in question has an interesting life cycle. It's born in what's called ephemeral ponds. That is, ponds that during the wet times of year gives rise to great reproduction rates. But then those ponds dry up. And as the ponds dry up, the little bugger then goes from the pond over to wooded areas where they then take the homes of other critters. So logs that have fallen in deep woods or trees that have fallen in deep woods, they don't actually make their own homes, but they take over other homes. They're kind of like crabs. Unfortunately, the little frog has been on the endangered species list now for quite some time, and its numbers have dwindled, so there is only one last pond that is home to this little creature. And they're thinking that there's probably less than 200 in existence. And so the Environmental Protection Agency, the Fish and Wildlife Service, in an effort to try to preserve these frogs, wants to try to designate critical habitat areas. they have designated in the past critical habitat areas. The only pond that currently exists where these frogs are situated is in southern Mississippi. And I have a map later on. As an aside, this year is a great year to work with your geography teacher for the Supreme Court, because there's lots of great place-specific cases before the court. There's nothing really thrilling, no big blockbuster cases on the First Amendment or religion or anything like search and seizure, but it's great for geography. So if you're looking for a way to do that, so there's a small pond in southern Mississippi, but before Weyerhaeuser, the lumber company, started cutting down large tracts of forests in Louisiana, there was home to this same frog. And it's still possible that this frog, if transplanted to that area, could regenerate. So the EPA and Fish and Wildlife have designated a portion of Mississippi and a portion of Louisiana as critical habitat. And so Weyerhaeuser is suing because it does not want its timberland to be designated as a critical habitat, and all of a sudden lumber operations must cease. Now, most of the area that was the lumber operations, they've already taken the lumber that they need, but what they're doing is they're selling or leasing that land to other companies, mostly oil and gas exploration, to try to find new natural resources. But the Park Service, or not the Parks of Fish and Wildlife Service, believes that if Weyerhaeuser was to stop, the sole survivor is Stephen Breyer. I hope that's not prescient, but they believe that if Weyerhaeuser were to stop their foresting or their commercial operations and the area was allowed to regenerate, that this frog could be relocated and the frog could then spread. And in thousands of other situations where the Fish and Wildlife Service has done this, mostly on public lands, there's been no outcry. This time, there has been a challenge. And so the court is considering the survival of this little critter versus the economic realization from companies like lumber companies, oil and gas companies, other commercial interests. And so they're weighing a couple dozen frogs against $2 million. So it's a tough case, but not anything that will scream, out for kids to get excited, unless they're biology students as well, and they think that this guy's pretty cute. So I told you at the beginning that I had these look into your crystal ball and say, well, here's the takeaways from last term. I'm going to start there because I think most of them are actually still relevant. And then some of them were miserable failures. So I've generated 5 more prognostications, so keep my average up. And then we'll jump into either last year's cases or this year's cases. But again, you jump in. This is an appellate argument. If you've seen an appellate argument, a lot of times the people arguing will say, may it please the court, Mr. Chief Justice, or Madam Chief Justice, as the case may be. And then they're immediately peppered with questions. So go ahead, interrupt. I really don't mind. In fact, I look forward to it. Yes?
Back to Kavanaugh.
Yes?
So is will the FBI really, truly, genuinely look, or is this just the appearance of an investigation?
So the way it was described by Senator Flake was it was to be limited in duration and limited in scope. It was only to look at the first 2 allegations, the one dealing with Dr. Blasey Ford, and then the one dealing with the Yale, the first-year Yale co-ed. What's that?
Ramirez?
Yeah, Ramirez. I'm sorry, I've got too many names in my head. But then they were also limiting it to only aspects of that. So the FBI is set up to do investigations. The FBI can do amazing investigations in short periods of time, but it appears that because of their brief on this, they may be limited in what they can actually look for. So they're trying to interview Mark Judge, who was the big, the hole in the whole thing on Thursday. he could have solved the whole thing by saying, I was there, or I don't recall, or whatever, but by not calling him at all, it kind of like, well, what's the point of this? So I have confidence that the FBI will do a thorough investigation to the extent it can. Over the weekend, it appeared that the White House had put more restraints on exactly what the people they could interview, and the scope of the investigation. The White House came out yesterday and said no, they did not put those restrictions on. The FBI can question anybody they want, and so I think it's going to keep going back and forth on that. I suspect that at the end of the week, the FBI will come back and say that they did the interviews. Nobody can remember to the beyond even a reasonable doubt that this actually happened or not. And so I think it gives cover to Flake and Collins and Murkowski and potentially Heitkamp and Manchin to vote and confirm Judge Kavanaugh. I think one of the areas that I'm not sure if they're able to question has to do with some of the ways that he may have perjured himself on Thursday.
Yeah.
I did not go to school with Brett Kavanaugh, but I went to a school very similar to Brett Kavanaugh, and I was probably a couple years before him. I can tell you what he wrote in his yearbook and what he said about what he wrote in his yearbook is not accurate, because I suspect that people from my high school wrote similar things in their yearbook, and I know exactly what they meant. I also know that some of his recollections about, and some of his classmates, both from high school and from college, testify about his drinking habits, his drinking problem, quite frankly. The question is whether that disqualifies someone from being a Supreme Court justice. If I were Brett Kavanaugh, I would have owned up not to assaulting, at the time, Ms. Blasey. But I would have said, you know what? The motto in my high school and then at Yale is study hard, party harder. That was actually the motto of the college I went to. I'm not going to identify that college. And so yes, I was number one in my class. I made it into Yale. I was captain of the basketball team. I played on the football team. All of that stuff. Fess up, say, we went to a lot of parties. I don't recall the one that she's specifically talking. Certainly doesn't seem in my character, but I can't remember. Certainly after my first year at Yale, I came to this great realization that if I actually wanted to do something with my life, I probably needed to study harder and party less. And so I had a sea change in my attitude, and ever since then I've led an exemplary life. I think a lot of people would be okay with that. Not about the assault or the alleged assault, but the I don't know, but I did some things that I'm not so proud of. It worked for George W. Bush, right? Remember his youthful indiscretions dealing with illicit drug use? And when he was it was when he was about 38 years old. So Kavanaugh could have gotten up to the time he was appointed to the federal bench and said youthful indiscretions, and theoretically that would work. I don't know. So I have faith in the FBI to do the investigation, but I don't know the extent that they're handcuffed in doing that investigation. A week is plenty of time as long as they have access to the people who they need to ask questions. But I wouldn't be too optimistic about the answers they're going to get. They're going to get a lot of I don't recall specifically to this event. And then we had the prosecutor who was hired to do the questioning on Thursday morning. She came out with a report over the weekend that basically reported to the people who hired her, the Republicans or the majority on the Judiciary Committee, that said that based on the answer she got, there would be no way that she would bring criminal charges. But that's not the point. It's not a criminal proceeding, it's a job interview. And the question is, given the fact that she got to interview one witness and 10 minutes of another witness before she was basically fired from her job, that's what I would expect. I didn't realize that she was going to actually issue a report, but it doesn't surprise me. So does that kind of get to where you're going?
Yeah, I just wish you had a cheerier answer for me.
Well, So the cheerier answer might be that, if something else, week is a long time in politics. It's a really long time in this politics, the current political setting. It seems like every hour there's something else going on. And so Lord knows what's going to happen in the next week. And if more people come forward, or if they really do focus on his drinking habits and then show that was actually perjury, at that point we no longer have the person, but we have my red question mark. And there are some people waiting in the wings, one of whom would be worse, one of whom would be about the same, and one of whom would be a lot better, given where I think your politics may lie. So I don't know. I guess is my final answer. Question?
Yeah, so if the job of the Senate is to basically see if his temperament, or if he's got the temperament for the job, the sexual assault aside, do you think his testimony kind of hinders that? Because he was very, loud, outspoken, and how he turns some questions onto the senator. His interaction with
Senator Klobuchar was very unfortunate. He did apologize after the break, although I think that was someone tapped him on the shoulder and said, "You really need to apologize to her." And her dad was an alcoholic, and you got to tread lightly. I think that engendered that. I think those who were inclined to vote against him now are using that idea of temperament as one more brick in their wall. I think if you were inclined to vote for him, that's not going to bother you, because I think if you are falsely accused of something, you have a right to be incensed. At least that's what Jeff Flake said. I didn't watch the 60 Minutes thing last night with Jeff Flake and Chris Coons, but my understanding is that was the takeaway, is that I have no problem with him acting that way, since he's perceived to have been wronged. And I would probably act that same way too if someone just kept dumping garbage on me that was not correct. So I think it reinforces, and I don't know about the middle. I suspect that Collins, Murkowski, and Flake are waiting for the specifics of the FBI investigation to either say no or give them cover to say yes.
Yes, but Judge Kavanaugh withdraws. Does it look like there is enough time to have a confirmation of an alternate before midterm elections?
I would guarantee that Mitch McConnell, well, not before midterms, but at least in the lame duck session, Mitch McConnell would make sure that there was something happening. And I don't know. I know the three people that would be on the short list for the next. And I suspect that if it was the Amy Coney Barrett, who's farther to the right than Judge Kavanaugh, I'm pretty sure that Murkowski and Collins would vote no on hers. So that would just be kicking the can farther down the road and emboldening. If the Senate happens to flip, then so the safer choice would be either Thomas Hardiman, who is more in the mold of Kennedy, or is it Judge Thapur, who's a Southeast Asian jurist, and he's a little farther. He's a little more to the right of Kennedy, but not as far right as either Kavanaugh or Coney Barrett. And we start talking about right and left, but as the last term actually showed, individual cases, the justices are all over the map. We talked about, there's this group of 4 liberal justices, and there's this group of 4 conservative justices, and then there was Kennedy, who was more conservative than liberal, but he would be the deciding vote in most cases. Well, he's gone, and you think, well, okay, do we have that still block of 4, and someone's in the middle? And one of my prognostications is that Roberts actually is looking forward to moving into that fifth or middle spot, even though his credentials are more conservative. So the entire court moves definitely in one direction. But and then the next justice is placed, on the right. So you have more cases that are 5-4 that way. But each of the justices has an area of expertise, and in certain cases, certain things might trip their trigger, and you end up with really weird judge agreement on certain cases. Usually not things that deal with free speech, free religion, the masterpiece cake shop case last term, anything like that. But you do have some bizarre pairings. So it's not fair to the justices or to the Supreme Court as an institution to talk about it in bold, left, right, and yet I do anyways. So there you go. So prognostication, or my takeaways, the chief is the chief. The chief has now been the Chief Justice. This is going to date me for more than 10 years. It's hard to believe that. And he has really shaped the court to be his image. And his image is, let's tone it down. Let's make sure that we can come to some consensus. Very much in the light of Justice Rehnquist, whom he clerked for. Kind of keeping it on an even keel, keep your head down. If we can decide cases in small terms, let's do that instead of making any kind of sweeping pronouncements like what happened, certainly under the Warren Court. Gorsuch certainly came out last term as being a solid conservative. Your first year on the court is always difficult because you're kind of feeling your way. But more and more, especially on the conservative side, they're following kind of a path set out by the Federalist Society. And so they're pretty known quantities. You know where they're going to end up on most issues. And he didn't disappoint in his term. I don't know if it's not surprising, but Elena Kagan has emerged as kind of the liberal leader on the other side. There were a couple cases this past term where in her dissent, she actually laid out a pathway for, okay, try again, but use this argument, and I think you might win over some of my colleagues. One of them had to do with the Wisconsin gerrymandering, and one of them had to do with the masterpiece cake, the same-sex wedding cake, where she said, okay, what? You're not going to win this time, but come back again and use this argument instead. And so she's kind of been signaling as an emerging leader for the left wing of the Supreme Court. Yeah, that was so wrong. About a week after I did my presentation in June, he announced his retirement. And so, yeah, we'll just skip that one. The number of cases considered by the court has fallen precipitously. It's still at really low levels. The court currently has 43 cases. They had 38. Last Monday, a week ago today, they met for what's called their long conference. They've spent the summer. Their clerks have been working diligently, kind of briefing cases, proposing things to be considered. The justices come back the week before their first meeting. They have this conference that lasts all day where they consider thousands of appeals. And out of it usually comes about 20 new cases, partly because there's only 8 of them, and they have no idea who the 9th person's going to be yet. They only took 5 new cases. So a lot of them, they kicked the can, so they didn't reject them, including one that looks an awful lot like the Masterpiece Cake Shop that deals with a Washington florist who is refusing to do a floral arrangement for a same-sex couple, the same way that the Colorado baker. But they didn't reject it, but they didn't accept it. They're waiting to see, who their 9th person is, and then they'll decide whether to take it or not. But the case load is going down, down, down. Part of that may be that there's uniformity between all of the district or all the circuit courts, and some of it may be we just don't want to touch this. I mentioned that there were some unlikely alliances. All of these statistics come from a really great resource. If you really are a Supreme Court nerd, go to SCOTUS blog. And SCOTUS blog has what's called their stat pack. And you can actually look at their stat pack from previous terms. In fact, now if you were to click on it, it would be blank because, well, the court hasn't come out with any decisions yet because they just started meeting this morning. But there's an archive, and you can look back, and a lot of these graphs and statistical analysis of who votes with who and who's friendly with who and that sort of thing, you can find on SCOTUS blog. And so again, if you're a Supreme Court nerd or a stats person, then this is the place for you. They continue to shy away from political questions by narrowly deciding cases on procedural grounds. There's the last justice, gone. So, for example, the gerrymandering cases from this past term, both in Wisconsin, where they said there was not a standing to sue, and in North Carolina, where they said it was not ripe for consideration, and in the Masterpiece Cake Shop, the Baker case. They said that they decided the case on procedural grounds, not on whether a cake artist must be forced to bake a cake for a client, but rather whether the Colorado Civil Rights Commission fairly treated this small business owner in their hearing. And they said, no, he was not treated fairly, and they used as evidence of that comments by some of the members of the Civil Rights Commission in media, talking about that this guy was not as religious as he claims and that sort of thing. So that poisoned the well, and so it was sent back to Colorado. Interestingly enough, the Colorado Civil Rights Commission has had another hearing with this guy, and again found that he violated the Colorado Civil Rights statutes. But it's not ripe for the court to consider again. It's got to work its way up. And so the court, until it gets to the right spot, is not going to consider stuff. Number 8 is the victory for incrementalism. They took a lot of really great cases last term. It's like, yep, we're going to go ski that double diamond. We're going to have good gay rights cases. We're going to have some free speech cases. We're going to have gerrymandering. This is going to be a great term. They got up to the top of the hill and realized how far it is down, and then they decided, no, let's just go to the bunny hill instead. So they really took the cases. We all thought it was going to be a blockbuster term, and then not so much. We learned some great vocabulary. My favorite is curtilage. I don't know if you knew what that meant, but I learned something new. In this year's case, there's an interesting factoid, just in case we don't get to it. One of the cases before the court this term has to do with hovercraft moose hunting. It's a thing. It's a thing in Alaska. And as part of the brief, the appellant cites that if Manhattan, the island of Manhattan, were as populated, had the same population density as Alaska, there would be 27 people living in Manhattan. So I don't know why that's not really relevant to anything except, wow, that's really interesting. Curtilage, for those of you who did not follow the case last year about Fourth Amendment, has to do with not your property itself, but the area that you still own that surrounds your property. In legal terms, that's called curtilage. So you own a house, and you own curtilage around the house, and it had to do with the car parked in the guy's parked in the driveway with the tarp pulled over it hastily. And so that curtilage is still considered property and within the control of the person owning the property. So I learned something new last year. And then last, and this always happens, is that they save the best cases for the decisions last. Mostly they release it in that last week, and as soon as the last one's out, they take off so that no one can criticize them. And usually they got these really, really cushy speaking engagements, or they're a visiting professor in some place in the Swiss Alps, or the Pyrenees, or yes, I'm going to spend the summer in Vienna. So they get out of town and let the media have at it, but they've made their decision and they escape. Plus, I don't know if you've been in D.C. in late June, but that's not the best time to visit because it's built on a swamp. But not a swamp that would support our friend, the dusky gopher frog. See, it all comes back. All right, so I was mostly right. Yeah. Kind of give me a B- on that. So I got new prognostications. And I really think that no matter who is elevated to the court, certainly if it's Kavanaugh, Chief Justice Roberts is now physically in the center. Even if it's someone like Thomas Hardiman, who is more probably, you can't use liberal, more moderate. I think Chief Justice Roberts likes the idea that he would be in the middle and gets to be the decider and kind of tries to manipulate both sides to, can't we all get along? He's a kumbaya kind of guy. You know, he really wants the court to maintain its relations with each other and present a solid front as much as possible. I think that there's a continued reluctance to weigh in on politics, especially given these confirmation hearings, where you really have. I mean, I've never heard of someone sitting there being interviewed for a job on the court who's railing against, you know, a particular political interest, and it leads you know, to believe, can he possibly be, or he or she, can they possibly be fair when they get a case in front of it? I mean, would Kavanaugh have to recuse himself every time the ACLU had an amicus brief? You know, of course, he would say no. But it does lead you to believe, you know, are politics being infused in the court? And I think that's why the court is trying to tone it down, at least for another year. It may be that they're only at 8, and until we get 9, we're not going to get anything any juicy. But at least for now, let's tone it down. Let's make sure that we're all on the same page. The continued low workload is the new normal. As I said, they're up to 43. They meet again this Friday to consider more grants. They met last Friday and announced nothing new today. So they're still at 43. They're going to get some more cases, but there'll be dribs and drabs. You know, there might be one here, one there. So I would be shocked if we get above 60 at this point. It is a year without blockbuster cases, although criminal law professors are looking at this because there are a couple of cases that pose interesting cases for first-year and second-year law students to consider, not necessarily your students to consider. It has to do with the definition of what is a house, you know, so you can search something. There's some states that have, you know, if there's evidence that someone has been living in their car on and off, that the car is then their house, and so it allows, you know, more protections about searching houses or searching cars. There's one that deals with mobile homes. You know, since it has the opportunity to be moved, does that mean that it's not a fixed domicile? You know, so interesting stuff if you're a Supreme Court geek, but no blockbuster cases for your kids to really get excited about. But that doesn't mean that the juicy cases won't return, because there are a whole bunch of them in the pipeline. You know that after this next round of elections and leading up to the 2020 census, there'll be all kinds of challenges to the gerrymandering cases. There is that Washington florist case. The court did not deny but refused to consider right now. There's a case out of Maryland that has to do with it's ostensibly a World War I monument, but it is a granite cross. And it's on public land, and so there's this challenge about whether this cross that was erected to memorialize World War I dead should have to come down because of its establishment of religion. So they're not doing anything with that, but eventually they have to make a decision, and so what that decision is kind of, you know, will be provide fireworks for another term, another time. How am I doing on time? Still got 8 minutes, I think. All right, so let's run through, and of course, we've already talked about the elephant in the room. We're not sure what's going to happen with him. So let me click through. I will load the PowerPoint onto the collection. My PowerPoints are usually just pretty pictures, and I just start talking, so I'm not sure they'll do you much good. But I do want to get to cases this term, because I think that there really is a great opportunity for you to talk about or focus on geography with your students this year. Last summer, I did a small workshop on the geography of gerrymandering through the Geographic Alliance, and I'm hoping that Alex thought that it went well enough that we'll do another one, because the cases this term are great for the geography of law. So let me focus first on the criminal law cases. There are 2 capital punishment cases. One is being heard tomorrow. They're both really interesting. The Madison versus Alabama, Madison, this case is from the 70s, I believe. Madison is now aged, infirmed, and demented. He has severe Alzheimer's. Does not remember the crime for which he was convicted and sentenced to die for. And so the question is, can we put someone to death for something that they no longer remember? And the argument on the one hand is, well, they remembered it when he was competent to stand trial, he was well within his faculties then, and that's the important point, not do you understand why we're flipping the switch or injecting you or whatever. But he's arguing that because he is not mentally competent to understand why he's being put to death, that capital punishment, the whole point of capital punishment, theoretically, is to, they understand what they did and why there's this severity of punishment. So they're going to be talking about that tomorrow in the court. Coming up is another interesting case where the appellant, Bucklew, who was convicted of first-degree murder and sentenced to die, has a rare blood disease that causes, almost like hemophilia, which causes him to feel pain with very little stimulus. And I'm struggling to remember what state this is in, but they want to lethally inject, because that's their primary one. And his attorneys are claiming that would inflict so much pain that it would be in violation of the Eighth Amendment, cruel and unusual punishment. In the alternative, he's proposed that they fire up the gas chamber, because breathing in the toxic chemicals would allow him to die in a more humane way. So it's not like he's saying, listen, I'm not saying I should be let off. I'm just saying that if you're going to kill me this way. Those of you who are, well, there aren't too many of you old enough to remember Gary Gilmore back in the 70s, who actually requested in Utah that he go in front of a firing squad. Right. So this is the firing squad case for the next generation. It's like, listen, I understand that you've sentenced me to death. Let me choose the method. And the state is saying, we're not equipped to do gas chamber executions anymore. Really, we're going to inject you. And so the question is, again, Eighth Amendment cruel and unusual punishment grounds, whether he should get to choose the most humane way to be put to death, which is really weird to say. I mean, just try that, the most humane way to be put to death. The double jeopardy has been around and around, and we don't mean the Alex Trebek double jeopardy. Double jeopardy, so there is this doctrine that's emerged called the doctrine of separate sovereigns. So if a person commits a crime in Iowa, and also the crime, that like abducted someone in Iowa, took them across the Missouri border, and inflicted another crime in Missouri, who gets to try them? Well, under the idea of separate sovereigns, both of them do. And the idea is that if they are found not guilty in Iowa, they can still be charged and found guilty in Missouri of basically the same crime. There's also the Federalist cake thing, where you can be tried first by a state, and then if that doesn't result in satisfactory, you can get tried again on the federal level. And if you remember some of the officers that were involved in the Rodney King incident, they were found not guilty by the California courts, but then found guilty by the federal courts. And so this is an attempt to resolve, is that double jeopardy? Is the idea of separate sovereigns still violating that idea of double jeopardy in the Constitution? So it's a fascinating criminal law case. Then we have the legal geography. We talked about our friend, the frog. So Glenn's Pond is the last known spot where this frog exists. The Nature Conservancy has created another ephemeral pond, and they're trying to transplant some of the frogs there. But the Fish and Wildlife Service have said that this plot of area in southern Louisiana, if they could just get the logging done, could be a really great spot for the frog to flourish. And so they've created that as a critical habitat. Now, back before there was logging and oil and gas and all that stuff, this little sucker was all over the place in Louisiana, Mississippi, and Alabama. But now it's limited to just one pond. So it begs the question, the value of one frog, or value of a species, and whether it's when you're balancing the economic interests versus the survival of a species, which way do you come down? The next one has to do with uranium mining in Virginia. The state of Virginia has outlawed uranium mining, but the question here is whether the state of Virginia has any say in it, because under the Atomic Energy Act in the 1950s, a lot of that was federalized, and so you have a controversy between the federal government that says we should be able to tell if you have the right to mine uranium, or the state in which it's held. And as you noticed, the uranium mine, this is the richest uranium mine in North America. So if we're going to create more nuclear weapons or nuclear energy, nuclear power, and we want to make sure that it's homegrown, it's got to come from this area that's in Virginia and North Carolina. And the fact that it's also in North Carolina gives credence to the idea that it's a national thing, that natural resources don't follow boundaries. You know, unless you're talking about rivers, and the rivers were what created the boundaries of the state, like Iowa with the Mississippi and the Missouri. But in this case, the uranium mines are throughout southwest Virginia and north central North Carolina. And so the question is, who gets to decide? And Virginia says you can do whatever you want in North Carolina, but you're not mining uranium in our backyard. And so that's going to be an interesting case. I talked about the hovercraft. There is a restriction by the federal government to prohibit hovercraft moose hunting in federal lands. But this Sturgeon guy, did you ever watch that show, Northern Exposure? There's that one guy, the big burly guy, who just kind of is kind of out there. It's been a while. I should have done some research for this. I should have watched some Northern Exposure episodes last night in preparation. But he was constantly talking, he was very libertarian, constantly talking about. And so this Sturgeon guy keeps bringing cases before the court. Everything imaginable that you can think of in Alaska, he's suing. This is his actual third time before the U.S. Supreme Court, this one dealing with hovercraft moose hunting. And he claims that the river that he's going to hover on is not owned by the federal government, it's owned by the state of Alaska, and so he should be bound not by federal restrictions, but by state law. And interestingly enough, Alaska has no state law dealing with hovercraft moose hunting. I'm pretty sure Iowa does not have a law covering hovercraft moose hunting, but that just could be. No, he does not. No. But he likes to be a stick in the side of everyone. So I know I'm over time now. I do want to get into, because this is the most fascinating of all the cases that the court's going to hear. It has to do with Native American claims. There's 3 of them, and they get progressively more interesting. So back when the tribe, the Yakima tribe in Washington, when their reservation was created, they were allowed to set their own tax structure. So the Yakima tribe owns a series of convenience stores like Hy-Vee, not like Hy-Vee, like Quick Trip or Come and Go or Casey's, called Cougar Den in Washington State. It's owned by the Yakima tribe. Well, they get their petroleum and they get their gas, and they have to get their gas to the various Cougar Den stores, and they have to use federal interstate highways to get the gas from where they're getting it to where it needs to be. But the corporation is Native American and subject to what they believe is the Yakima tribe restrictions, not the U.S. government restrictions. And so they're refusing to pay taxes on the gas and on the transportation of the gas to the stations. If there's a way station, and for some, you all pass way stations on your way here, they almost always say closed. But if they happen to say open, the Cougar Den petroleum trucks would just fly right by because they don't have to pay taxes. And that's what this case is dealing with, is the sovereignty of the Yakima tribe in Washington. This next one actually has to do with the creation of the state of Wyoming. and subsistence hunting on federal lands that may or may not have been allowed by the original treaty. The tribe, the Crow tribe, has a reservation in southern Montana, but when Wyoming was created, they kind of absolved. They said, no, the Crow doesn't get a reservation in us. They've already got one up there. But when they got the right to hunt, subsistence hunt, originally, it had a term that said other unoccupied federal territory. Well, Wyoming wasn't a state then. And so you could hunt in what is now Wyoming. And so the question is, this hunter who hunted elk out of season to feed his family and was arrested by the Wyoming authorities because it was outside of the reservation. Basically, he jumped over a fence. It wasn't that far out of the reservation, but he was out of the reservation. Whether he can be prosecuted by Wyoming for violating the hunting, or whether the Crow reservation extends to those unoccupied federal lands, which would include parts of Wyoming. And then the last one, I encourage you to do some research on this one, mostly because it could ruin the state of Oklahoma. Anyone from Oklahoma? Anyone Oklahoma Sooner fans? Okay, so good. I can say boo-hoo. Remember, Oklahoma, before it became Oklahoma, was Indian territory? And the sad history of Native Americans in our country is that we kept relocating tribes to Oklahoma. So you can't live here in the southeast, you Cherokee. Go to Oklahoma or go to Indian territory. Seminole Indians in Florida, sorry, we need this land, you go to Oklahoma. And so the 5 civilized tribes, this is in law, 5 civilized tribes, and I'm going to try this. It is the Choctaw, Chickasaw, Creek, Seminole, and Cherokee. The 5 civilized tribes, each had areas that were their traditional reservations in what then became Oklahoma. Theoretically, when Oklahoma became a state, these treaties were wiped out. But neither the Oklahoma legislature nor the federal legislature actually wiped them out. And so we have a murder case. The guy's not contesting the fact that he is a member of the Creek tribe who murdered another member of the Creek tribe. He's claiming that he was tried in state court and sentenced to death in Oklahoma. He said he shouldn't have been tried in Oklahoma. He should have been tried in federal court because Indian on Indian or Native American on Native American crimes held in Native American territory has to be dealt with by the federal government instead. So he thinks he needs to be retried in federal court, by which federal court doesn't have the death penalty for these cases. So he's trying to save his life, literally. But even more interesting is that the way the court decides this could determine whether Oklahoma as we know it exists. Because if those treaties were never actually stopped, these nations still exist in eastern Oklahoma, including half of the city of Tulsa. And they would then be away from Oklahoma, free, independent nations with their own laws and their own economy, and the poor people in Oklahoma would just occupy this part. So it could completely change the geography of the United States. We're right in the middle of this great country of ours. We have smack dab in the middle 5 independent countries from the civilized tribes. Interestingly enough, the 10th Circuit Court is where Oklahoma is, and one of the former justices on the 10th Circuit, or judges on the 10th Circuit Court of Appeals, is Neil Gorsuch. Neil Gorsuch was one of the people who actually allowed this case to go forward. So he's going to have to recuse himself. But his thinking, you think, okay, the conservatives are all going to vote one way. Not so much. Because private property is private property, and if it's private property for a Native American as opposed to private property for a landowner for gas pipeline or something like that, what's good for the goose is good for the gander. So I am way over time. I apologize. Thank you for spending the day or spending the morning. If you got other questions, email me or stop by. And thank you for your patience again. And I'm sorry that I ran over by 10 minutes.
Thank you.
Thank you.
Fascinating.
Yeah.
I didn't know this was a large group question, but I do have a little question about the Masterpiece Cake Shop.
Yes, yeah.
One of the arguments I heard was that availability also plays a role. That
Yes.
If it had been only cake shop.
Yes, so part of the issue here is that the baker went on that Cupcakes War show, right? And so got kind of national notoriety. And so the couple is claiming that it's a setup. Just know that right away it's a setup. But what their argument is claiming is that because of that notoriety, they wanted someone with that national reputation. And yes, there are other bakers around that could probably bake the cake, but I wanted that baker. It's kind of like in Des Moines, there's a cupcake shop just off of Ingersoll called Crema, and they get this big sign, as seen on Cupcake Wars, and so it's like, well, I want the person who's on Cupcake Wars to do my cake.
Gotcha.
And so that was their argument.
For why that doesn't apply.
Yes, and if you go back to the civil rights cases in the 1960s, like the Heart of Dixie Motel, there were other motels. But just because there's another motel right across the street that will rent rooms to African Americans, that doesn't mean that I can't. I can say, no, listen, you guys go across the street. No, it's a restraint of commerce thing.
That was my question. The whole availability thing seems wrong to me. Because how do you determine who gets to deny and who doesn't get to deny?
Right.
That he would sell cake and said he didn't want to do the artistic.
Right. He did say, I have cakes that are on display. Pick one, and it's yours.
I think
but
that was-
the next time around, it's going to be on free expression grounds, where as an artist, a cake artist, I shouldn't be forced to produce my art for a cause that I either don't believe in or don't have sympathies with, or I fundamentally disagree with. So I mean, this thing's going to keep going around and around and around, because you've got the commerce, you've got the equal protection,
And
you've
the
got
Colorado food board, it's like they keep kicking the hornet's nest too.
Yeah. Now the Civil Rights Commission did a better job this time, but it's still the same commissioners, and you can say the water was poisoned the last time. The same way that liberal groups might say, well, Justice Kavanaugh, is going to vote this way. The water's poisoned. He already showed his stripes on this, and so why should we have this? Why should he have to hear our case?